दोस्तों नमस्कार। आज एक बहुत ही इंटरेस्टिंग केस आपके सामने प्रस्तुत करने जा रहा हूं और ये केस है एक ऐसी महिला का जो भारतीय नागरिक थी और दुबई में जाकर के उसने एक पाकिस्तानी नागरिक के साथ में शादी कर लिया और उस शादी के बाद उसके दो बच्चे हुए। दो बच्चे होने के बाद दुबई के कोर्ट ने उनके तलाक को मंजूर कर लिया और दोनों बच्चों की कस्टडी मां को दे दी। मां टेम्परेरी पासपोर्ट के आधार पर भारत आ गई और यहाँ पर रहने लगी। जब वो टेम्परेरी पासपोर्ट एक्सपायर हुआ तो उसने रेगुलर पासपोर्ट के लिए अप्लाई किया, लेकिन रेगुलर पासपोर्ट नहीं मिला। उसके बाद वो महिला कर्नाटका हाई कोर्ट में गई और कर्नाटका हाई कोर्ट ने जो फैसला दिया है वो मैं आपके सामने पढ़ के सुनाता हूँ। बहुत इंटरेस्टिंग केस है। ये लोग जहां मर्जी वहां पर जिसके साथ में वहां पे शादी कर लेते हैं, उसके बाद में इस बैकडोर से एंट्री करते हैं। अभी अगर कर्नाटका हाई कोर्ट इनके बच्चे को इंडिया की सिटीजनशिप दे देगा तो उसके बाद यही बाप जो पाकिस्तान का नागरिक है वो बोलेगा क्योंकि मेरे बच्चे यहाँ पर इंडिया में हैं तो मुझे भी हिंदुस्तान की नागरिकता दी जाए। इस तरीके का कुछ गेम चल रहा है। एनीवे, उस बारे में जाने से पहले मैं आपको केस पढ़ा देता हूँ। In the High Court of Karnataka at Bengaluru, dated this the 28th March 2023, before Honorable Justice M. Nagaprasanna, writ petition number so and so this. ये कौन है? आयशा मलिक और अहमद मलिक, दो बच्चे हैं। पटिशनर इनके ये सुदर्शन साहब एडवोकेट हैं, along with श्री अनिरुद्ध एके एडवोकेट्स। ये पटिशनर के एडवोकेट हैं। रिस्पोंडेंट है यूनियन ऑफ इंडिया, डिप्टी कमिश्नर बेंगलोर अर्बन डिस्ट्रिक्ट, डीसी ऑफिस बेंगलोर, मिनिस्ट्री ऑफ एक्सटर्नल अफेयर यूनियन ऑफ इंडिया साउथ ब्लॉक न्यू दिल्ली। और इसमें आदित्य सिंह साहब सेंट्रल गवर्नमेंट काउंसिल है जो अपीयर हुए थे। और ये जो है श्री बीजी कृष्णा, ये बेंगलोर के गवर्नमेंट के लिए थे। दिस petition is filed under Article 226 and 227 of Constitution of India, praying to direct the respondent to consider representation dated 5 March 2022 of the petitioner through their mother, produced herein with as an Annexure J and etc. This petition having been heard and reserved for orders coming on for pronouncement this day, the court made the following. कोर्ट ने ऑर्डर क्या दिया? ये 29 पेज का ऑर्डर है। बहुत ब्यूटीफुली ड्राफ्टेड ऑर्डर है और इसको एक एक वर्ड बहुत इंपॉर्टेंट है। The petitioner are before this court seeking direction by the issuance of writ in the nature of mandamus to consider their representation dated 5 March 2022 filed through their mother, natural guardian, for issuance of passport in favor and also grant them citizenship in terms of law. Heard Sri Sudarshan, Learned Counsel, appearing on the petitioner, Sri Aditya Singh, Learned Counsel, Government Counsel, appearing for respondent number 3, and Sri V. Krishna, Learned Counsel, for respondent number 2. Brief fact of the case are borne out from the pleading are as follows. The petitioner are the children of one Srimati Amina Rahil and Sri Ashad Malik, mother and father, who will be hereafter referred to as such. The mother of the petitioner is an Indian citizen. The father of the petitioner is an Pakistani national. Marriage between the two would take place on 11/4/2002 at Dubai, UAE. The petitioners were born from the wedlock at UAE and are currently aged 17 and 14 years respectively. Along with the marriage and birth of the petitioners, herein there were non-compatible issues between the father and the mother, and accordingly the They approached the jurisdictional personal court at Dubai. The court, on considering the application in terms of personal laws applicable to wife and husband, dissolved the marriage on 7/9/2014. After the resolution of marriage, the mother of the petitioner was conferred the permanent and sole custody of minor children, that is, petitioner reunion the husband and had himself recognized all his claim over the custody of children and had filed an agreement before the concerned court in Delhi. Thereafter, the petitioner are in custody of the mother in the government, which in tune with record produced. The petitioner then approached the Indian consulate at Dubai and submitted a representation that prescribed form for conferring Indian citizenship, and the consulate appears to have directed them to surrender the Pakistani passport, which the petitioner had in their favor, being the children of Asad Malik, the father who was a Nepali. The petitioner then surrendered the Pakistani passport with the Indian consulate in Dubai. It is therefore Islamic Republic of Pakistan consulate issued no objection to correspond with the Indian consulate at UAE and complete formalities. अब यहाँ पर पाकिस्तान कंसुलेट ने उनको एनओसी भी दे दिया और इंडियन गवर्नमेंट ने उनका पासपोर्ट सरेंडर करवा दिया. When the petitioner wanted to come to India, they had no Indian passport. At that point of time, the Indian consulate at Dubai, on representation made by the petitioner, had given temporary Indian passport on so and so. With an endorsement that citizenship status of the petitioner is pending with the Ministry of Home Affairs and passport is issued on humanitarian ground. The petitioner, on the strength of the temporary passport, traveled to India and are now staying in India with their mother. The passport having expired, the petitioner submitted representation to the concern and have been so representing for the last 1 year. Those representations have been gone unaided. The petitioner are driven to this court in the subject petition seeking a direction by issuing a writ in the nature of mandamus for considering of the case for conferment of citizenship right and as sought in the representation. The learned counsel appearing for the petitioner could contend that petitioners are in a situation where they have no identity. They have surrendered their Pakistani passport, but that had they had which were granted to them on the sense of their father being in Pakistan. Temporary passport granted to the petitioner clearly indicated that citizenship of the petitioner was pending before the Ministry of Home Affairs. The situation now is that petitioners are nowhere without any identity. Since the mother of the petitioner is an Indian citizen and the marriage between the Pakistani national and the mother Indian citizen is dissolved by complete court of law, the petitioner will have no now we will have to be treated as citizen of Indian citizen and be granted Indian citizenship accordingly and consequently passport the names. On the other hand, London government senior council association representing the respondent Burman 3 would immediately refute the submission to contend that it cannot be such as easy task as it projected by the petitioner. The constitution it does not permit dual citizenship. The Citizenship Act 1955 mandate that one has to surrender citizenship of another country to become a citizen of India. Pakistan Citizenship Act does not permit surrender of citizenship of any person unless he crosses 21 years age. Therefore, unless the petitioner surrender their citizenship cannot be considered citizenship by this country. The petitioner will have to wait till completion of 21 years of grant of citizenship, as it can only be considered after surrender of their existing citizenship to the other country. He would contend that mere surrender of passport before Pakistan consulate would not mean that they have renounced their existing citizenship. He would therefore contend that the petitioner be dismissed. London Council for the petitioner in reply to the aforesaid submission would submit that he has filed an application seeking amendment of the petition raising a challenge to the communication rejecting the request of the petitioner on 29/9/2002 and also bringing notice to this court that the first petitioner has attained the age of 18 years and it is only the second petitioner who is now represented by the mother, la guardian. He would contend that the ground on which the communication comes about is erroneous and it is directed that a petitioner may apply in terms of Section 5.1 read with Section 2.1b of the Act and seek grant of relief as well. Now, the court says, I I have given my annexes consideration to the submission made by the expert to learned councils and have perused the material on record. The aforementioned fact, though not in dispute, may require a little elaboration. The story of this issue begins on 11/4/2002 when the mother of the prisoner, who at that time was an Indian national, that is holding Indian passport, get married to one Sri Assamese holding a Pakistani citizenship. From their wedlock, on so and so, the first petitioner is born, and on so and so, the second petitioner is born. The entire family's right from the date of marriage, as aforesaid, was residing in UAE. क्या हुआ?
आप यहीं पे चलना है अपने को 12:30-1 बजे के आसपास। वो होली फेस्टिवल है, सुनील जी ने भेजा था।
नहीं, मैं नहीं जाता।
मेरे को एक पूछना है, एक इम्पोर्टेंट काम है, वो हीलॉक लेना कैसा है? तो फिर मैं रिमोटली उनको पूछूंगा, उनको लगेगा यार हमें हर टाइम मेरे से सिर्फ काम की बात कर रहा है, 1 घंटे में आ जाएंगे।
ठीक है।
वो न्यू जर्सी में है, मैं पहले उनको पूछता हूँ कि आप कंफर्म आने वाले हो ना? हाँ। अगर वो कहेंगे हाँ तो ही जाएंगे, नहीं तो नहीं जाएंगे, और 1 घंटे में जाके आ जाएंगे। हाँ।
The entire family, right from the date of marriage, as aforesaid, was residing in UAE. The marriage has also taken place in Dubai. After about 12 years of their marriage, dispute arose between the couples, and accordingly they applied for divorce before the court or competent jurisdiction in UAE. The concerned court, in terms of the order dated 7/9/2014, resolved the marriage between the couple. While doing so, the custody of the children was granted to the mother. The mother then continues to stay in UAE. It is the averment of the petition that it became difficult for her to continue to stay in Delhi, and therefore wanted to come back to India as she was an Indian citizen, but the children did not have Indian passport. The mother represents before the authorities seeking grant of Indian passport. The passport is granted on humanitarian ground with the following note. Citizenship register of the applicant is pending with the Ministry of Home Affairs, and passport is issued on humanitarian ground. With the aforesaid quoted endorsement, the passport was granted to first child, that is daughter, same kind of passport to the second child, the son, on the strength of grant of approach by the Consulate General of India, Dubai issued a certificate in favor of the petitioner's reading. Miss Aisa Malik, who was Indian passport, holding Pakistani passport number so and so, has been issued Indian passport number so and so by Consulate General of India, Dubai, with validity from this to this. Her Pakistani passport with UAE visa, stamp valid so and so, has been surrendered in Consulate General of India, Dubai. This certificate is issued on being requested by the applicant's mother to produce before immigration authority during exit from UAE. Similar certificate is also issued in favor of the second petitioner. It is indicated that first petitioner was holding a Pakistani passport, which is indicative of the fact that she was a Pakistani citizen and now she had been issued Indian passport by Consulate General of India, Dubai, which was to be valid up to this. Her Pakistani passport, which was to expire and so, had been surrendered to Indian Consulate General of Dubai. A certificate was issued for the production before immigration authorities at Dubai. The children came to India, complete their studies complete their studies Jyoti Nivash Pre-University College and Oak Ridge International School, and the mother submitted a representation on so and so seeking citizenship to children. The representation dated read as follows. From Amina Rahil, 34, blah blah blah. Request to record its Indian citizenship in favor of minor so and so. When the petitioner did not reply to the petition, the petitioner knocked at the door of court seeking a direction to the consider petition so remitted during the pendency of The petition of Citizenship Court to be rejected on so and so. The order of election is as follows. As per the action procedure for processing the citizenship application, all relevant documents are uploaded by the district collector, and therefore citizenship case is being processed by district collector of the city in online mode in the citizenship module, and therefore it is sent online to the ministry. The central government disposed the application in terms of the provisions of Citizenship Act 1949 rules made there under especially rule this. It is informed that the citizenship of India is governed by the provisions of Citizenship Act 19 rules made there and under further details of the in the case, it has been observed that you have not applied for grant of Indian citizenship in respect of minor children online so far. One of the parent mother of the minor children is an Indian citizen, with father of the Pakistani national. In order for consideration of this, both the parents are required to be Indian citizens. Therefore, the children are not eligible for registration as Indian citizens in the terms of however you may apply under the relevant section of this issue with the approval of the representation is disposed of with the process direction that the mother has to make application according with the act or with all necessary documents that are required to be considered. The submission of considered for the petitioner that the children are entitled to the Indian cannot at this stage be accepted as the father of the children was a citizen of Pakistan, a Pakistan national, and mother and a citizen an Indian national. Both did not reside in India but were residing in Dubai. After the divorce were granted by Dubai court, custody of the petitioner was handed over to the mother. By then, the children had to be declared to be citizens of Pakistan by virtue of the father being a Pakistan. In fact, children held Pakistan citizen and Pakistani passport. It now becomes germane to notice Section 4 and 5 of the Citizenship Act. सिटीजनशिप एक्ट की कॉपी है पूरा। मैं इसको पढ़ करके आप लोगों को टाइम वेस्ट नहीं करना चाहता। अगर आपको पढ़ना है तो सिटीजन एक्ट का ये चीजें पढ़ लीजिए। Section 4 of the Act prohibits dual citizenship, as if a citizen who is beyond 18 years or minor cannot be a citizen of this country as well as of any other country. Section 5 1D permits citizenship to those children whose parents are citizens of India origin, notwithstanding the fact that they are residing outside India. Therefore, to claim citizenship under so and so, both parent of the children who seeks to claim must be an Indian citizen. In the light of the aforesaid quoted legal framework, the communication made by the Consul General of India, Dubai, and the President of the other requires to be noticed. It reads as follows. The Consulate General of India, Dubai, communicate to the Consulate General of Islamic Republic of Pakistan, Dubai, bringing to the notice of the Pakistan authority that they have been approached by the mother of the children, an Indian national holding an Indian passport, who is married to so and so. The Pakistan national holding passport. It has been indicated that on census of Pakistani nationality and surrender their passport, they may apply for registration of both and passport by the Government of India, Dubai. The consulate further observed that the person need to renew the passport of this gentleman to notice Pakistan under the section 14 of the Pakistan Citizenship Act की बात कर रहा है. Deals with renouncement of citizenship. A child can renounce the citizenship of Pakistan or regain within 1 year after completion of 21 years of the reply rendered by the applicant requires to be noticed. It is read as follows. Consul General of Islamic Republic in the aforesaid reply observed that under Section 14 of the Pakistan Constitution, only an individual above the age of can apply for her citizenship. This by virtue of which his or mother children below the age of residing outside Pakistan will cease to be citizens of it. It is categorically indicated that minor children cannot renounce citizenship of Pakistan by himself or herself. Pakistan authorities would further indicate that they have no objection for grant of Indian nationality to the children. Therefore, the situation is now under the Act. No person can hold a dual citizenship, be it a minor or a person beyond the age of admittedly. Both the children who have now knocked at the door of this court, even at the date of citizenship of Pakistan, as their citizen has not been announced in terms of law of Pakistan, unless they announce the citizenship of Pakistan, they cannot become citizens of India. It is not a case where these citizens are without citizenship or landless or stateless, even as on the date they are citizens of Islamic Republic of Pakistan. It is the law of Pakistan that do not permit them to renounce citizenship of Pakistan. The Consulate General of Islamic Republic of Pakistan at Dubai is curricular in his reply that a minor child children cannot renounce the citizenship of Pakistan till they attain the age of 21 years. Unless they renounce the citizenship of Pakistan, the Citizenship Act 1955 does not grant citizenship to those persons who are already citizens of another country and who are also hold passport of any other country, be it a major or minor. If law of Pakistan are inflexible to a situation of this kind, so far as the law of this nation, which cannot be made flexible in the peculiar fact of the case, the children who are now seeking their Indian citizenship can seek only after they renounce the citizenship of Pakistan, as admittedly the biological father is a citizen of Pakistan. The children are declared to be citizens of Pakistan. The mother may be an Indian citizen unless the violence is done to the language of the Citizenship Act. The children cannot be granted citizenship as they are already citizens of Pakistan, and this code, by its order, would not indulge in any such violence to the language of the mandate of the statute. Section 5(1)(d) of Act mandates that both parents are required to be Indian citizens for the purpose of grant of citizenship to the minor, and therefore, it is clearly indicated in the order that all the documents which would be necessary for grant of citizenship would be produced before the authority. If the law elsewhere that Pakistan does not permit renunciation of citizenship by minor up to the certain age, the law of this nation would not permit grant of citizenship to the person. Therefore, it is for the mother of the petitioner to produce all the documents necessary before the concerned authorities in India for an Indian citizenship to be accorded in terms of this. To reiterate, the children as on today are not stateless. They are citizens of Pakistan. They have only surrendered the passport, but they have not renounced citizenship of Pakistan. Mere surrender of the passport does not amount to renunciation unless such renunciation comes with about no direction could be issued to the Ministry of Welfare to consider the case of the petitioner mother for grant of citizenship to the. Therefore, it is for the mother to place all those materials that are sought by the authorities to consider grant of such citizenship in favor of the petitioner. No mandamus would lie in the peculiar fact of the case. For the first reason, the following order petitioner stand rejected. Petition stand rejected. So this is the case. अब क्या बोल रहे हैं कि अगर मदर और फादर में से फादर के सिटीजन बाहर की है और मदर के सिटीजन इंडियन का है, तो बच्चों का सिटीजनशिप ऑटोमेटिकली जो फादर के सिटीजनशिप की वही होगा। और सिटीजनशिप इंडिया की तभी मिलेगी जब मदर फादर इंडिया के सिटीजन रहे हों, तभी उनको मिल सकती है और इसके अलावा नहीं मिल सकती है। तो ये कैसा केस था जिसको मुझे ऐसा लगता है कि ट्रेस करने के लिए डाला गया था, टू ऑब्टेन इंडियन सिटीजनशिप for the kids who are born out of the wedlock of a Pakistani father and Indian mother. चलिए देखें, अच्छा केस का था, मतलब जजमेंट तो अच्छा था। अगर इस वीडियो से आपको कुछ ज्ञान मिला होगा, आपके ज्ञान में कुछ वर्धन हुआ होगा, तो आप मेरे इस वीडियो को लाइक करें, दोस्तों यारों के साथ सोशल मीडिया में इसको शेयर करें और मेरे चैनल को सब्सक्राइब करें। मिलते हैं अगले वीडियो में। वंदे मातरम, जय हिंद, नमस्कार।